The disagreement within the legal fraternity over judiciary services at Huduma centers has escalated, with an advocate moving to court to stop the planned launch of the services. Chief Justice Martha Koome and the executive have been formally sued under a certificate of urgency following the decision of the judiciary in conjunction with Huduma Kenya to set up judiciary desks in Huduma centers. Advocate Carolyne Kamende Daudi argues that the move threatens the independence of the judiciary. Seth Olale with the latest.
In an affidavit sworn by advocate Carolyne Kamende Daudi and filed by her lawyer Levi Muneri and a certificate of urgency at the High Court, the Chief Justice of the Republic, the Chief Registrar of the Judiciary, the CS Ministry of Public Service, Delivery and Performance Management, the Chief Executive Officer Huduma Kenya, and the Attorney General have been sued for collaborating to have a number of judicial services offered at judiciary desks in Huduma centers. The petitioner, who has listed LSK as an interested party, argues that the judiciary has made an administrative decision to collaborate with the executive in the performance of its exclusive function of administration of justice in a manner that undermines the independence of the judiciary and the hallowed doctrine of separation of powers. And that the Law Society of Kenya was not consulted before the judiciary made a decision to transfer some of the judicial services to judiciary desks to be domiciled at Huduma centers under the Ministry of Public Service, Delivery and Performance Management. The petitioner further argues that the decision contravenes or threatens Article 10 of the Constitution of Kenya, 2010, as well as Section 31 of the Advocates Act, Cap 16, that obliges all state organs, state and public officers to conduct public participation when making and implementing public policy decisions. In her bid to have the process, which is scheduled to commence on Monday, the 29th of January 2024, as per the notices and memos, stopped by the High Court, the petitioner argues that if the program is launched, it will irreparably injure the administration of justice, as any court document filed will stand void and may have to be filed afresh at a later date, to total detriment of the litigant. The petitioner further arguing that persons masquerading as advocates are eagerly awaiting the rollout of the program to take advantage of the unclarity in its functionality to unlawfully circumvent advocates and illegally offer the services of advocates to unsuspecting members of the public. In certifying the petition urgent, High Court Judge Lawrence Mugambi directed the matter be mentioned on 18th of March 2024 for further directions, with responses to the application and the petition being filed within 14 days from the date of service. Seth Olale, Citizen TV.